Good morning. I think we're going to go ahead and get started with the 10 o'clock employment law panel. My name is Kristen Bates, and I'm an attorney with the Strong Firm PC here in the Woodlands, Texas, and I am the co-team leader with David for the Woodlands Area Business Summit, and I'm the moderator for today's employment law panel update. Joining me today are Stephen Quezada with Gray Reed McGraw, Danny Ramirez with Monty Ramirez, LLP, Josh Redelman with Stibbs & Co. attorneys, and Lee Winkelman with Winkelman PLLC. I'm going to tell you. I'm going to tell you a little bit about each of our speakers today. We have some exciting hot topics, some updates that we're going to go through that our speakers are going to tell us about, especially from this past week. It's been a fun week. And then we're going to open it up for Q&A afterwards. I have my Whova app if you want to submit questions and answers. Otherwise, we'll be walking around the room because I'm sure that some people are going to have questions for our panel as well. So I'm going to tell you a little bit about our speakers and our panelists today. Stephen Quezada, again, he's with Gray Reed. He is a board certified in labor and employment law, and his practice focuses on representing public and private employers in all types of complex matters before federal and state courts and administrative agencies that enforce numerous laws impacting the workplace. Danny Ramirez, he's the name partner at Monty and Ramirez. He's board certified in labor and employment law, where he represents public and private employers in labor, employment, and immigration matters. He provides legal advice to businesses on HR issues, implementing best practice initiatives, conducting internal investigations, and he represents employers during government investigations and lawsuits. Josh Redelman with Stibbs & Co. has extensive experience providing guidance and legal counseling to businesses, both large and small, on numerous employment law related topics, such as the American with Disabilities Act, the Age Discrimination Employment Act, the Family Medical Leave Act, and providing guidance on the Fair Labor Standards Act. Lee Winkelman is a practicing attorney. He's general in-house legal counsel, and he's a professional speaker. He leverages his understanding in drafting HR policies and employment agreements to achieve his clients' strategic business and risk management goals. He regularly represents employers in EEOC and Department of Labor investigations and in employment disputes before both judges and arbitrators. Thank you all for being here today. The first kind of update and hot topic that we're going to talk about are sexual harassment laws, regulations, and updates over the past year. This past year, Texas has expanded several sexual harassment protections for employees in the workplace beyond those offered under federal law. There are three profound changes that we have seen with regards to sexual harassment claims. First, the law now applies to all employers regardless of size. Second, the law has changed how soon an employer must take action. And third, the laws now regulate who all may be liable for sexual harassment claims in the workplace. Let's start with Danny. Can you shed some light on what are some of the major implications for employers under these new regulations?
Yes, definitely. Traditionally, Texas is an employer-friendly state. And I think it's been a while since we've seen some changes in the state laws that really are employee-friendly. And this is definitely it. The changes Kristen mentioned, I think significantly that I think are really important for all employers to know because it applies to any Texas employer is lawsuits have traditionally been able to obviously sue the employer, the entity, right? The corporation. This law opens the door and allows an employee who claims sexual harassment to sue an individual who might be involved in the wrongdoing. And so candidly, this is a new law that went into effect September 1st, 2021. And I think the courts have to define what that means. But the way the law has been revised is that this could mean that a plaintiff, and I think it will happen strategically from the plaintiff's bar, is they will sue HR directors, they will sue managers who are engaged in the alleged wrongdoing, or any other individual they think is part of that wrongdoing. So I think, for those owners, HR managers, and in-house counsel folks, they need to think about what that means strategically inside with their employees, whether it's training, whether or not you have an indemnification provision as far as what you're going to provide as representation if an individual is sued, and other items. And then lastly, briefly, before I hand it off, I think is, they did increase the bar as far as what's expected from an employer in relation to investigating. The general standard, which was the federal standard as well, is that an employer had to promptly resolve something, resolve the sexual harassment. The terminology has changed, and the Texas legislature specifically changed that to state immediately. So there must be immediate action, which is a change, and that has not been officially defined by courts, but I think it's definitely going to be an issue that will be litigated when these cases get filed.
And I'm just going to open up if anyone has more comment.
Sure. I think something that's really interesting about that is HR and the immediate impact is, as we're going to the online workforce and a lot of people working from home, employers are starting to monitor more, and they're having software monitoring of their employee communications. And what is the implication of if somebody in HR or somebody in the IT group is monitoring employee to employee communications and sees that a supervisor is harassing one of the employees, sending lewd messages, sending pornographic images. These are the types of things that we see in these cases. What is the reporting requirement there? And under the immediate standard, are they required to immediately investigate that action? I think that's an unknown implication here, and something that employers and business owners need to be aware of.
Yeah, I just add that probably a lot of people don't understand, but the federal and state employment laws generally only apply if you have over 15 employees. So, traditionally, well, besides race, I guess, under Section 1981, but smaller employers have been able to discriminate on the basis of sex, on religion, et cetera, all the protected characteristics. So, they haven't needed to have policies in place on this stuff. Now, having said all of that, like, if you're using that as an excuse to discriminate against your employees that you're too small, like, shame on you. You need to do better. So it is important that if you don't have these policies in place, you have absolutely now need a sex harassment policy.
Yeah, and I'll just piggyback on to what everyone has said a little bit. I wrote an article on the change that got published in the Texas Law Book, and it focused on specifically that immediate standard and who the proper party defendant could be. And so the immediate standard, while new to Texas, isn't new to other jurisdictions. There are plenty of other states, at least 3 or 4 or 5, that have this immediate standard. So if you look at the case law from those cases or from those states that talk about what immediate means, it's you're doing something that day. The employee comes and reports. Do we need to separate the employee? We contacted HR. We set up times for interview. It doesn't mean you need to go and get the complainant and put them in a room somewhere and do the interview that day. You've done something to put the wheels in motion. Generally, we'll have to see what Texas courts say, but that's generally what other jurisdictions say. In terms of the proper party defendant, I think Danny's right. I think HR directors need to keep a heads up, because if you look at how sexual harassment is defined in the statute and what the obligations of the employer are, it does seem broad enough that if there's an HR director who does not act immediately when the employer has that duty to do so, then they have failed and maybe opening themselves up to liability there. And so it's the definition of the proper party is whoever acts directly in the interest of an employee. It's not as broad as other statutes like the Fair Labor Standards Act, where you can see company owners get sued, where it says whoever acts directly or indirectly in the interest of an employee. So it's a little more narrow, but it does open it up. And lastly, I'll just say lots of employers have started using arbitration clauses and contracts. And most of those arbitration agreements say they're between us and the company. Well, what happens if the employee sues the HR director, sues the manager? Is your arbitration agreement broad enough to cover that? If not, you're going to be in trouble, and you might be in two different venues potentially. So that's my sort of key takeaways from the change.
Quick point on what Stephen had just mentioned. As an attorney that represents employers in this space and represented employers in sexual harassment lawsuits, I definitely think this shifts some weight on in favor of a plaintiff who has a sexual harassment lawsuit. I think generally speaking, it was a fair playing field, but the fact that, strategically, if I was on the other side of the bar and I were to sue an employer in relation to a sexual harassment lawsuit, if I wanted to get things a little sticky and get it, not as clear, I definitely would push the envelope and sue the HR director, sue the potential alleged harasser, and who else, that might be involved. That's not something that we're accustomed to, in relation to that additional factor in that lawsuit, because, asking the questions, well, is this manager allegedly engaged in that bad conduct? Is the employer going to provide a defense to that manager? And if not, what's going to happen and how will that affect the lawsuit? So now that alleged bad manager and the employer are no longer aligned versus being aligned in that defense. So it does create a wrinkle that, we've not had to deal with, in the past 18 years of my practice. And I do think it does shift in the favor of the plaintiff's bar in relation to sexual harassment lawsuits. Keep in mind, this is only for sexual harassment law, not anything else in relation to that perspective.
And it sort of reminds me of a disability case, right? You get a disability discrimination case, or a failure to accommodate case, or a scenario that an HR person calls me up about and says, hey, we have an employee claiming X, right? They've made this internal complaint. In disability claims, I feel like the first question I always ask was, what do we do for the interactive process? When did we find out there might be a need for an accommodation? When was the request, and what do we do for the interactive process, right? I feel like these sexual harassment claims are going to become like that. When did we find out? When did we act? And what did we do? That's what it sort of reminds me of.
And just a quick takeaway. So, asking yourself as an owner, business owner, HR director, or high-level manager, what should your company be doing? I think you definitely have to revisit your policies to look at, what's your investigative process? What, does it state prompt remedial action will be taken, or will you guys take prompt action? Should you consider changing that terminology to we're going to take immediate action? Is that necessary? In addition to that, training to your managers across the board, I think should be done as soon as possible. This law is already in effect. I think managers and those level individuals should have knowledge about what this law can do, meaning they can be sued hypothetically if a plaintiff claims that they're engaged in the alleged sexual harassment. And then also employers should look at what are their policies internally in relation to providing a defense. And when I say that, will a company pay for a manager, an HR director's legal defense if they are implicated in a lawsuit down the road? Those are just three general issues that you need to visit. There might be others, but just as a best practice, that's what I think is a takeaway, at least in relation to what you should be looking at for your employer, for your company.
Yeah, just to add real quick to that, I think indemnification is the word people need to start thinking of. And you're going to see a lot more indemnification agreements between, just employers and, managers, that sort of thing, HR directors. So.
And check your insurance policies.
No, thank you. Josh?
And your arbitration agreements. I'm a big fan of arbitration. And I think if you have a broad arbitration agreement that covers claims between employees is something that you're definitely going to need now.
No, I think that's helpful. I think, thank y'all for covering what the law, implications for employers, what it means, and some key takeaways on that. So we're going to move on to the next topic, another hot topic that we've seen really over the past few months. We've seen President Biden issue mandates to employers with regards to COVID-19 vaccine protocol. In September, we saw federal rules come out regarding vaccination requirements for businesses with 100 or more employees. And just this week, in the past few days, and as of yesterday, new federal rules have been released regarding vaccination testing and max requirements on the job. Can you explain the major takeaways from the recent mandates and maybe give us some of your personal predictions on what we may expect to see still in the future?
lawsuits.
Mhm.
So many lawsuits, all the
Uh,
lawsuits.
16 hours ago, Florida sued the Biden administration over the ETS. So for people that don't know, OSHA was created in 1970 by Congress, and Congress gave them their the Commerce Clause powers. And there's been 10 to 12 ETSs in the history of OSHA. 6 of them have been challenged. 1 has stood up in court. So my personal prediction here is that this is going to go to court. It already is. And I think the Biden administration has a timing issue, and I think it has an arbitrary issue of the number of employees. We're close to a lot of restaurants right here. And I think the Biden administration and OSHA is going to have a tough time defending the 100 employee limit because the COVID-19 virus does not stop at a restaurant, at the front door of a restaurant. It does not stop when you sit down at the restaurant. There is no reason, and that scientifically, I mean, the science is going to have to come out about this, that somebody working at a mom and pop restaurant that sees 500 people a night or 1,000 people a night would be less inclined or less likely to get COVID-19 than somebody working at an office building. I went into the restroom today, and the Lone Star has the pump for the sanitizer. Why is that not enough with the mask? Why is that not enough? What is the vaccine requirement? How does that play into it? So I think those are some of the issues that OSHA is going to have to defend against. As far as kind of the updates, I mean, $14,000 fine if you don't comply. Employers, employees have to pay for the vaccine. You've got a deadline in December and a final implementation in January. January 4th is the deadline that you have to implement these policies. You must have a vaccine or testing policy in place. I mean, there's a whole enforcement. There's so many things. I mean, I'll pass it off because I don't want to hog up all the air.
I before we go further, I just want to touch on what the mandate is, right? Because so many people have called me and said, "Hey, the mandatory vaccine. It's not. Here's what the mandate is." Okay, I'm about to tell you. It's vaccine or testing and face mask.
Right. And just to kind of elaborate a bit, and Josh is right, like who knows what's going to happen, right? But I think from an employer's perspective, my recommendations are we need to be ready, and we don't know whether an injunction will be upheld. And, you know, we're forecasting, and I'm not sure, but in relation to what's required, the ETS, which is the rule issued by OSHA, was released today, was published. And so some deadlines have triggered. The first deadline is 30 days out from what I understand, is that employers must come up with the policy, must decide internally, what are they going to do, right? So we're going to mandate the vaccine 100% with our workforce. Or as Steven said, if you're not going to have that 100% across the board, you can mandate the vaccine with exceptions, meaning that if employee does not, like, I don't want to take the vaccine, fine, you'll be required to test every 7 days. And, you know, those are for employees that are in fact working within the office, interacting with people. It does not apply to employees working outside, like construction workers. And then it does not apply to employees who are remote working 110%, meaning that I'm showing up every day working at my home office and I'm not interacting with people. So there's no need for me to take the vaccine or get tested. And so deadlines are, you know, 30 days, come up with what your policy is. And then in 60 days, I think it's Jan 4th, 2022 is when the testing must begin, right? And in relation to, you know, it's going to be a little administrative burden, I think, to kind of manage the second option if you offer the 7-day testing. So even before that, you've got to take a log in relation to who's vaccinated, who's not. And then separate from that, you've got to have someone who's going to be logging those every 7 days, right? I mean, and if the test comes back late, they can't work, you know, someone's got to track that issue. As far as leave options, they get up to 8 hours of leave, paid leave, to get the 2 vaccines. If there's side effects with the vaccine, they get up to 4 days. And then separate from that, I think it's just managing the process. There's a lot of nuances in relation to what's required that I'm not messaging, just there's a lot of detail, but I think from a 20,000 foot level, that's generally what's required. So forecasting, you're going to mandate it across the board and everyone has to take it versus you're going to mandate it, but provide the exception in relation to the testing. And then last point is, if I fall into a category, if I have a medical condition, I can get an exception. I can get a temporary medical condition, like if I'm gonna have surgery in 30 days and I can't have that vaccine, that could be a temporary option. Or if I have a disability, which would be an ADA exemption, or if I have a religious exemption, I could be exempt from it. So some moving parts in relation to what to manage, but that's the forecast of what it will be required. And as Josh and this panel have mentioned, I think my recommendation is let's be ready for it. We have to plan for it until there's an official federal decision from a federal judge somewhere saying that it's going to be temporarily, put on pause.
Yeah, and I will add in, because we are in Texas and Governor Abbott has issued what people reported as a ban on vaccine mandates, and it's not a ban on vaccine mandates. That's how it was titled, that's how it was messaged, but it's not. It reinforces what Danny was saying about religious exemptions, ADA, and also adds a conscientious objector status to it. The Biden administration has come out and said that the OSHA regulation preempts. So that will be another thing that will play into the question of federalism and police powers, and what does Texas, the executive order from Greg Abbott, control? I don't know if we're still in special session, but I know he charged the legislature to pass something also banning vaccine mandates with private employers. I don't think they did, but there is the executive order out there. So with Texas litigation, at least, that might come into play, the question of preemption.
So I wouldn't rely on waiting on a federal court injunction. I don't think that you can. So I haven't seen every federal case that got filed. Most of them got filed this morning. What I read this morning was 11 attorney generals filed a lawsuit in the 8th Circuit in St. Louis, Missouri, which I guess they can go directly to the Court of Appeals on this, which I thought was weird too. And it's based on interstate commerce, which I didn't think was the strongest basis. The way OSHA gets to do these emergency temporary standards is by showing that there is some grave danger to workers, right? That's a pretty tough standard, I think, especially as the pandemic goes along and sort of, community spread lessons and stuff like that. So I would think that there are going to be also lawsuits challenging the ETS based on that grave danger standard, but I don't think you can wait on that. The ETS has very specific requirements on what must be in your policy, and it's not just vaccine or test and mask. You have to tell them about PTO. You have to give them a notice that OSHA has put out. There's about 8 or 9 things that go in there. And as you're crafting this policy, I think it's a best practice to include in there that people must present truthful information and proof of vaccination that is true and correct and that pertains to them. Because there's a lot of, I think, sort of funny business going on with the vax cards, to say the least. And right, it's like, right, when I started doing like I-9 training, we'd talk about how, folks would go get documents at the flea markets. Well, now it's like, folks are going to who knows where to get some vax cards, right? So be sure to include that in the policy as well. And then on the paid time off component, because I know that's hitting a lot of employers, you cannot take paid time off for the person when they go to get the vaccine. I'm going to mess this up. Let me just give me a second. You can take paid time off when the person goes and gets the vaccine, but you cannot take the paid time off when they're out sick from side effects from the vaccine. You also cannot make it go into a negative leave balance. So.
And I'll just say this really quickly. This is a situation where employers are getting pushed at two ends because they've got the issue of the federal government, breathing down their necks. They've got this policy they've got to implement or face fines. Employees are also going to have religious exemptions. They're going to have disability exemptions, et cetera. And I've heard of some employers actually coming out and saying beforehand, we're going to give very limited exemption. We're going to be very strict with exemptions or something. I don't know. I don't understand that, because you're just going to get sued. I mean, you're going to get sued by somebody here, and it's more likely you're going to get sued by the employee than the federal government at the end of the day on this particular thing. So I don't think it's the employer's job to go in and examine, is this a deeply held religious belief, sincerely held, et cetera. I mean, if they've got a religious exemption, they've got a religious exemption, period.
One point that Stephen mentioned is the policies. OSHA did provide like a 6 or 7 page draft policy that they recommended as a guide. So I think it's a starting point. If you're going to take a stab at it, I'd look at the OSHA, draft policy that they put out. I think there is a balance. I'm not disagreeing with what the panel's saying. I've had to help employers walk through some employee situations when they've taken a religious exemption stance. And most recently, this employee had Googled some general letter that was off some alleged religious institution. And, we found that out just through Googling, but I think there is a balance. I think we can't be too aggressive in relation to challenging an exemption. And I think it depends on your capacity as well. But I think sometimes employees will push the envelope from that perspective. And that one example, an employee put forth a fake letter and made some assertions, and the exemption wasn't provided. And once we challenged, or at least informed the employee that what is your religious exemption based on, and went through some interactive process with that employee, she backed down immediately and just was ultimately vaccinated. So I think there's a balance, right? I think we've already seen employees push back and they feel uncomfortable about it. I'm not saying that those employees are necessarily bad employees, but some employees are in a situation where they feel uncomfortable and they're getting advice maybe from a wrong source in relation to what to do. But I think they have to be careful as well, is because they're misrepresenting information to an employer. And just like anything else, they're not being truthful. So they need to be careful from that perspective as well.
I guess if you see flying spaghetti monster, right, that's the thing to look out for. That's not a real religion.
Yeah.
And just to ask for purposes of clarity, I mean, you've covered a lot of all this. What employers does this apply to? What size businesses? Because in the past, you have small businesses that say, oh, I'm a small business, certain things don't apply to me. Just
it's an employers with 100 more employees. And I haven't fully analyzed this, but it does include part-time employees. I'm not sure how the count is, how the part-time equivalent count is, but just generally speaking, it's the same. Okay, so it's 100 employees and you count the part-time employees. Same count as the ACA count? Yeah. Is that?
A part-time employee is a whole employee.
Okay. So
they do not count.
and it depends if they're truly independent contractors is the question. But I think if
Shall we move?
That's
to
right.
FLSA?
Yeah, we don't wanna get
In the FAQ, it says they do not count, but that's right. If they really are independent contractors.
Don't just make all your employees independent contractors. That doesn't work that way.
Please
okay?
don't.
Please don't.
Be sure to get one
And
of my
hire
business.
us. I mean,
I can tell you're the wily one. You should get one of my business cards because you're gonna need me.
yeah,
so our businesses
there's a
are
question.
are
Right?
smaller businesses. Any, feedback, implications, any recommendations for them?
Do you want to take the question from the audience real quick, or?
Yeah.
So as far as the religious exemption, it has to be a sincere belief as to a religious institution that has taken a stance in relation to saying that their members and the religion doesn't permit the vaccine. It is a little different in relation to the religious standard, unlike the disability standard. If there's a de minimis burden on the employer, which means if there's a low issue, if there's a lower standard that basically applies, that it's not as high as a disability accommodation. So with the religious exemption, an employer can push back slightly depending on the facts. But that said, I guess you're asking if they do have a sincere religious belief, will they be exempt from this mandate? My understanding is they would be. That's not eliminated.
they still have to get tested though weekly. Do they still have to comply with the testing? So they
Yes.
still have to wear a mask and get
Yes.
tested. Yeah.
Correct. Yeah.
Correct. Correct. So I guess it would be if you have a policy where your vaccines you only allow for vaccines or something like that,
Mhm.
you have to give the employees the option to say, I've got a religious exemption from vaccines, but I'll have this thing shoved into my brain on a weekly basis and get tested, that sort of thing. So.
Yeah, one of the interesting things presented by a religious exemption is, so the Pope has come out and said everyone to get vaccinated. And I've heard from employer clients say, okay, well, you're Catholic. The Pope said, get vaccinated. You don't have a religious exemption. That's not the case. Just because the Pope said it, if
He
they
wasn't
have
speaking
if they have an issue with the vaccine based off of their interpretation of their religion, you got to be careful about, as Danny was mentioning, there's a balance you have to find there. But just because the Pope said it does not mean Catholics cannot have a religious exemption for the vaccine.
So when someone comes and asks for a religious exemption, you're essentially looking at two things. What is the religious basis for the exemption request? Meaning what part of the doctrine says no vaccine? And then second, is the belief sincerely held? Those are the two things you're asking, right? So, and then on the de minimis standard, I want to also mention, because sometimes, all you had to do was turn in a letter from the deacon, right? And so then you get 20 deacon letters, right? And who knows how much they had to tithe for all these deacon letters. And so you're allowed to look at holistically, what is the hardship or burden that will be put on the enterprise. If we have one religious exemption, okay, fine. But now we have 20. Okay, that's so you can look at the grand scheme of things, if you will. Mhm. Correct.
And know that the medical exemption is distinct from the disability exemption. So someone can have a disability of whatever, I'm just making this up, could have, cancer and can't take the vaccine, and that's a disability, versus there's, I think, two types of medical situations, temporary ones. The surgery example I gave, if I have a surgery in 30 days and can't take the vaccine, or separate from that, I just have a medical issue that's preventing me from taking the vaccine.
So they're able to do at-home testing, but they can't test and then report the results. It has to be two different people or two different entities. So if you want to take an at-home test, the person whoever's reading the test, it can't be the same person.
Give them what? Give them benefits or give them paid time off? You give them the paid time off. Yes.
Just, yeah, the PTO specific to this, not any additional PTO that they would not be entitled to.
I know we had another question over here.
I'm not familiar with the deadline or expiration.
There's
of
no
the-
deadline.
There is no deadline in the ETS. The ETS can only be in effect for 6 months, and then it has to go to a proposed rule and go through the regular rulemaking process at OSHA. So the ETS is over in 6 months from January, so in June, but most likely there will be a follow-on regulation about COVID-19 in the workplace. But the ETS cannot, it's not a, I mean, it can kind of be a gap filler, but it cannot be a permanent rule. They have to go through the regular rulemaking process at OSHA.
And since there are some smaller employers, I'll mention this about the count. It's, do you have 100 employees on November 5th? Or do you hit 100 employees after November 5th and while the ETS is still in effect? And well, what about the opposite? What if I'm 101 and 2 people flake out and quit on me? If you were covered, if you slipped into coverage, you're covered for the duration of the ETS.
101, get rid of 2.
We had another question. Go ahead.
Yes.
The way I read the ETS is it's enticing employees that are not vaccinated to get vaccinated. It's going to be a pain in the butt to go get tested every 7 days out of pocket. And from what I understand as well, if I'm one of your employees who decides to get tested every 7 days, my time taken testing is not compensated. Is that right? I mean, the employers don't have to pay. The ETS says that's not compensable, but I guess it's an FLSA question about whether an
Right.
employer has to pay.
Correct.
And I think there's an argument to be made, just like jury duty, employees have to go to jury duty and you can't prevent that. You don't have to compensate an employee just because it's state law to go to jury duty. I think there's an argument to be made that maybe it's federal law that requires this testing. I'm not compelling you. Do I have to compensate you? I think that's a risky like proposition, but I think there's some employers that might take that stance.
And so compensability of time spent testing on a mandatory test. Think of when you send an employee to go get a drug test, right? They have an accident at the workplace or there's a near miss and they go get drug tested. That's a mandatory test that they must now take. That is compensable time. The FLSA says those types of mandatory tests, there's 3 or 4 things you got to meet, that's compensable time, right? So I think the most conservative advice would be, yeah, go ahead and pay that time spent testing. But to assure yourself, somebody's like, oh, well, I work in the Woodlands, but I think I'm gonna go get tested in downtown Houston, and they go and wild out. And after they go get tested and they're waiting on their results, pick a provider. Tell them this is where you're going to go. This is where we are. These are the places where around the business that you can go. Right. Put some boundary lines on that. Yeah. So if over-the-counter tests are acceptable, so long as they're approved by the FDA, and the test can be administered on site. So you the employer, can say, we're going to go buy 50 test kits, and we've got 4 employees who have opted to test weekly, right? You can do that so long as you follow the instructions specific to the test and administer it. And then it still needs to be 2 people watching, right? You can't test and read it.
Or the employee can buy those tests like at Walgreens, and the HR director hypothetically could verify the result. I think it's the vaccination card, and then maybe a doctor. I mean, if there's a doctor's letter, hypothetically, if I misplaced mine, a doctor's letter confirming that I have the vaccine, and I'm sure there's some other options, but I think those are the traditional ones, the ones that we're, seen in the mainstream.
It's the Vax card. It's a vaccination, some sort of other vaccination record. It's the record that you took the vaccination from the provider. But most interesting, I thought, was if something happens and the employee cannot get their vaccination record, the ETS does allow the employee to submit an attestation with certain specific language under penalty of, perjury and that sort of stuff, that they have been vaccinated. I didn't think that would be in there. I was sort of shocked to read that was in there.
Yeah, and one thing about the testing is the employers, I don't know if we've mentioned it yet, but the employers have to keep record of it. So whenever you're keeping your employee medical records, you have to keep it as a separate file. So all the testing, it's going to become a very large file. You have to keep, the employer is required to keep record of the tests.
Questions over there?
Yeah.
I haven't seen any of the lawsuits challenge that 100 employee threshold?
I didn't hear the question part past the part of, I know you aren't attorneys. My mom would be disappointed if I didn't say, no, I'm a lawyer.
We're
No,
all
it's okay.
for lawyers.
It's okay. It's okay. I'm just messing with you.
She asked whether, if I understood the question correctly, whether the 100 employee threshold would likely be challenged based on,
I think the question was whether or not they'll just move to a rule that says, well, fine, everybody's got to get tested. Then.
Right.
You're going to complain about 100
Right, right.
employees, right?
Yeah, I don't know if that's been challenged yet. It's just something that I see an issue with, but I don't,
It basically is a point to say that this is an arbitrary policy, right? So we're going to attack this rule by saying that it's arbitrary and capricious or something along those lines. Like there's no good reason. What about 99? What about 98? You know what I mean? And so that's where this 100 employee thing comes in. I mean, the ETS has already been written. And so, it's like, are we going to, if this gets, upheld in court, are we going to get to, it's going to take a while. I don't know if we'll ever get to the point where it would be, that's just my personal view. That it would ever be changed.
So the ETS is about 400 pages long. And if you're a loser like me, what you did yesterday was read 400 pages of ETS.
Loser.
And there's an actual, so in the preamble to the ETS, it does give rationale for why the 100 employees. And it says that based on OSHA's findings and surveys and stuff like that, it thinks that employers who have 100 or more employees have the administrative capability of doing this. And so it thought with fewer, and it's not to say that somebody with 90 or 95 doesn't have that administrative capability, right? Maybe you're employing some stepdaughter nobody else will employ, and she sits around and you've got 99 employees and she could do this for you, right? But generally that's what the thought was. And there's a portion that says this 100 employee threshold is something that we're going to re-examine, and maybe it goes to 80, maybe it goes to 50. But right now we think with 100 or more employees, there is some administrative capability at that employer to manage this.
So that's a very good indication that they would not go to, like, say, a very small number of employees if they're looking at the administrative capability of the employer.
So let's touch on just a couple other topics. Also, Josh Cherry, when he spoke, he said it. He said, since January 2020, none of us are doing business the same, right? We've all been impacted. We're all transitioning. All employers are just doing business differently. Hot topic today, definitely a lot to say about COVID vaccinations, mask requirements. How else are you seeing your clients impacted by the pandemic and how they're shifting business models? We do have an HR hot topics panel. They're going to talk about, work from home and things like that. But what are you seeing, in terms of your clients from a legal perspective with regards to work from home policies, accommodations being made, leave, hourly employees?
I think we've seen it. The pandemic changed the way we do business, right? I think traditionally I was in the corner where I thought we had to go into the office every day and we were more productive if we were face to face. And that dramatically changed after the pandemic. And so I think employers across the board had to modify their policies, from supervising, tracking time when employees are on the clock or not. Are the work areas safe in the employees' homes? Sexual harassment and race discrimination can still occur virtually. And also just kind of know, we've always traditionally, when we conduct investigations, traditionally said, let's pull the emails, right? But now we're way beyond emails. We're in texting. Are you retaining any chat box messaging that occurs on the MS Teams or Zooms? The emojis are now part of the messaging. It's not just, actual words and letters. Emojis can mean a lot of different things. So I think that remote workplace process with employees now working, whether it's 25% or 100% across the board, has changed our lens as an employment attorney to kind of analyze things differently, right? I think things have definitely broadened, and I think it does take employers to be more broad in relation to what their policies traditionally said and how they investigate items and how they oversee employees working remotely, because it has changed compliance across the board, just generally speaking.
I think performance management, and I know this is going to be talked about on the HR panel, so I won't talk about it much, but I think performance management in terms of defensive documentation, if there is a problem with that employee, and it happens when we're closing the books at the end of the year and realize they haven't done X, Y, and Z. Okay, well, how did you not know that before, right? I think that's a critical thing. And I also think that if workplaces haven't adapted to some opportunity to work from home or work remotely, be it 1 day a week, be it 2 days a week, I think that's coming for most workplaces. And I think that lots of employers are actually opening their eyes to doing that, because what's happening? We're using less copy paper. We're using less pens and pencils in the office. There's less Diet Cokes. Somebody's not drinking the 6-pack of Diet Cokes a day, right? And so, I mean, this is business, right? And the business reality is it's cheaper to have people working from home. And so I think a lot of people are going to start doing it.
Yeah, I think that it just took employers getting past this notion that if an employee is not in the office, they're not working. If I can't see them working, it's like if a tree falls in the woods and there's no one to hear it, doesn't make a sound. If employees at home and I'm not watching them work, are they actually working? And I think that it's taken a lot of, it's basically moved employers from a micromanaging process to an outcome focused process, right? So I'm going to give you work to do. You need to get it done. I'm not going to sit here and watch you do it and I have heard the most there is something, I don't know if you work for a company that does this, quit immediately, but there's like this goof off app thing where it's like, it takes a picture of you every minute or something like that. Yeah. It's ridiculous. Yeah. So I think that this is the biggest thing that's come out of this. I don't want to get too HR on it, but is it's required employers to just trust their employees a lot more to get stuff done, period.
Josh, I know you didn't speak, but you're going to be speaking on a breakout in a little bit. You want to touch on like data protection, remote employees, everybody's working remotely, they're at home or wherever they may be. What are you seeing employers doing? What's some tips on just data protection?
Yeah, data protection from the point of view of non-solicitation, your confidentiality agreements, data protection from secure network connections, limiting what you can plug into a computer, whether you allow the employer work from home on their own personal computer or whether you allow them to print from that computer. There are some that keep laptops air gapped and you can only access certain things and need to know information. So start siloing your information to ensure that when they're at a hotel on the road or at a sales conference, that their laptop and they leave their laptop out, all of your information isn't compromised. And then also restricting access. I mean, everybody does not need to have access to everything. We had a case where a guy popped in and decided he was going to try to download the entire system. Thankfully, the client had a system in place to stop that. But if they did not have a system in place, they could have stolen the whole company. And also, whenever employees turn in their computers, you need to have a log of what employee has what device. So whenever they resign or they get fired, that you have accurate recording of that, and starting to see employers move more towards instantly imaging a computer if they suspect that they're going to a competitor, and looking to see what kind of emails have been sent back and forth. Everyone writes things down, and that's, whenever you're enforcing a trade secret case, you're enforcing a restrictive covenant, that's kind of our dream, to see that employer or that the former employee has been emailing the new company for the last 2 weeks and talking about, these are the clients I'm going to take. This is how much business they do. This is the pricing on them. That's all in the email. But what happens, and I'm glad that employers are starting to do it, what happens is, okay, they take this laptop and now they turn it over. Well, they've just wiped all the data. You have to protect that data because that is vital to us making our temporary restraining order argument, making our argument for temporary injunction, and then finally securing a result where the former employee likely gets fired, and you move on down the road.
Danny mentioned the chat function and stuff like that. I think businesses need to go, and if there isn't a retention policy, think about a retention policy for that stuff. And if there is a retention policy, re-examine it and make sure it's effective enough right? Because it's going to be, oh, well, we were on this conference and then he sent me a private chat and the private chat had the eggplant and the peach, right? And here comes, you know what I mean? And now you got a problem, right? A couple people smiled. That was for you. And if you didn't smile, you need to go look it up.
Before we wrap up here, top tips and takeaways that you have for employers in dealing with post-pandemic business operations, remote employees?
I mean, there's a lot, that's a pretty broad question, but I think as far as what we've discussed today, I think for certain, some tangible takeaways that you can go back to the office and at least look at are your sexual harassment policies, right? In relation to the heightened level of, issues that we discussed. What have you done to revisit those, and what have you done to provide training? And in relation to the individual liability, I think is one takeaway for sure.
So for post-pandemic workforce, I think as people start to re-enter the workplace, you need to get your training going again. And particularly in the EEO and sexual harassment realm, you need to get that training going again, because this isn't sort of the sexual harassment world of the past. It just isn't. Me Too changed that. This new statute changes that. You need a robust policy, at least for your managers, I think, in-person training that incorporates your policy, incorporates what to do when somebody makes a complaint, incorporates where to go to make a complaint. And that is a real training, not some click through the slide, ignore the video sort of training.
Yeah, and I think employers need to go back and look at their employment agreements. Do they have the broad arbitration agreement? I'm a big fan of arbitration. In Texas, you can get away with a lot of things that you can't get away with in California. You can force arbitration on people for the most part. You can restrict discovery. You can force the employee to pay for it. If you do it the right way, you have to do it the right way, of course. But there are ways to make an arbitration agreement discourage frivolous lawsuits. And as we see the new generation coming up and people moving from job to job between 2.5 years, that's the average tenure for somebody in Gen Z is 2.5 years staying at a job. The gone are the days where people are working 40 years and getting a gold watch at the end of it. That's done. That's not going to happen anymore. So employers have to be prepared, and their employee retention and their employee training and interaction, ensuring with the online workforce that they keep people engaged so they beat the average, because nobody wants to be training a new employee every 2.5 years. If you can beat the average of 2.5 years, you're doing well. 2 years, 3 years, 4 years, 5 years, you save that money, save that training, you keep the institutional knowledge. So that's something that employers really need to pay attention to keep their online workforce engaged and feel just because they're working at home, they're still a member of the team.
I would say that you really should communicate with your employees. I mean, I shouldn't, that's an understatement. The pandemic has changed the way the employment landscape, probably more than anything other than the Industrial Revolution. Okay. It is literally changing the space in which we work. And I think that it's showing us that employees work differently, right? People are different. Some people like to work from home. Some people hate working from home. Some people can't work from home. And whenever the pandemic first hit and people were working from home, I got getting calls from employers about, these employees that are unproductive at home and that sort of thing. They're just, lazy or whatever. No, the fact of the matter is they didn't have a good setup, right? They have a screaming kid running around. They got Legos everywhere. They're not in a place to be productive. So communicate with your employees, make sure if they're working from home, that they have a separate home office, that they can be productive, and then it's safe, because we didn't talk about this. Workers' comp applies if you're working from home. If you suffer a work-related incident at home, it's a workers' comp claim. Anyway, point is, make sure that your employees have good work environments at home, and just set it up to where your employees are succeeding. That's what's going to make an employee leave. If an employee feels like they're behind the 8 ball and there's no way they're going to get ahead of this company because the company won't let them work the way they're most productive, they're going to go somewhere else, or they're going to become an independent contractor or do something else. So, yeah. Care about your employees.
Do we have more questions?
The question was, could you sue the alleged harasser under the new law? My interpretation is that the revision does permit a plaintiff, once they go through the EEOC process and exhaust their remedies there, and they have a right to sue, they can, yes. I don't know if they'll be successful, and I'm not sure how the courts will interpret it. It's pretty fairly new, but any other?
you could sue the individual harasser now under Title VII. It's just now you can do it with Title VII is 15 or more employees.
Okay, that's all the time we have. If you have more questions or anything, the Whova app will still be active. You can submit questions and I'll have our speakers look at them and see about providing responses. Thank you so much for your time and for all the wonderful information.
Thank you all.
Thank you.